Hey, let's start. Oh my God. Okay, let's start today's session on point of the legal system and methods in the war. So those who are going to be a barrister after the starting moment from the side of LLB. Okay, let's move. Discuss major in terms of the legal system and methods of the war. This is the DHAKA law. This is the legal system, please. Just share this video. At first, I would like to discuss in terms of the English legal system. The English legal system, and then we will try at a level base. Okay, we're in lab video. The English legal system prescribed how it can be prescribed and what are the main legal system in the war. Those should be maintained and those should be discussed in this session. Okay, viewers, just join in this video. Okay. Oh my God. How much and how it can be discussed. Okay. Well, today's session on point of the English legal system. The United Kingdom is divided into three main jurisdictions or self-contained legal system. Okay? First one is England and Wales. And second one is Scotland. And third one is Northern Ireland. Its jurisdiction had its own laws, court system, lawyers and judges. However, but how can we actually share this video? I don't know. We are lag behind to share the video. In the world, there are mainly five categories, or the five categories of legal system which are practiced in the whole world. Those should be my, what exactly there are five basic types of legal system in the world. Whether yes or not, if not, just share and comment here. Ladies and gentlemen, there are five basic types of legal system in the world. They are civil law. First one is civil law. Again, please. Only two persons are with me. No one is watching this video as they have no power from the side of Michel Foucault or Mr. Laka Shahid or the power exerciser in the war Barton Russell. They're not watching this video. So no matter, we'll start our discussion on point of the legal system in the war. And those who are going to be a barrister in future life, you have to follow the instruction of the law doctor. And Afroz Asha is watching this video. Only one lady in the world is watching this video. No problem. Now I would like to discuss on point of the basic types of legal system in the world. First of all, there are five basic types of legal system in the world. You have all know in this regard. They are civil law and the common law and customary law religious law and hybrid that can be interchangeably used, that the mixed system. This is the mixed legal system in the world. Today, mixed or hybrid system are common because its system varies by country. This chapter will focus on this characteristic, what exactly the traits of each kind of system in the world. After the observation of the world map, we will easily comprehend that what are the legal systems existing in the world. Okay. Only one lady is watching this video. This is sham for the whole nation. So those who are going to be a barrister in future life, you must follow the instruction of law DHAKA. Okay, first of all, note that before discussing different law system, it is significant to distinguish between what the term civil means and the context of legal system, and what it means in the term of civil versus criminal laws. We have no concept at all. So let's start. At first, we would like to discuss in terms of the common law system. What is common law system in the whole world? That the mapping system or the presentation is still in terms of the pie chart on the basis of the bar chart. Okay, those should be discussed later. But first of all, we have to focus in terms of the common law system in the whole world. The US legal system, this is the US legal system and other legal system that emanate from British rule is a common law system. Originally, common law meant judgment law. What exactly the judgment law? Have you any idea? What is actually called the judgment law in the world? We have no idea in this regard. Judgment law prescribes that the landmark decision or the leading case, that the ratio decided or omitted dictum will be kept in from the situation. We need to highlight or the pressurize and point of the judgment law. Okay, most of what exactly the US legal system and other legal system that emanate from British rule is a common law system. Originally, common law meant judgment law that filled in gaps when there was no written law, just looked to pure decision to determine the unwritten law. This is treated as the precedent. According to Mr. Jurist, several jurists in the world, Professor Salmond, Austin, what exactly the Holland, all the jurists in the world, the focus on point of the judgment law in, according to jurisprudential view, we have already studied in this regard that the precedent, persuasive, and what exactly the persuasive precedent. So this is judgment law. And judges looked to prior decision to determine the unwritten judgment law and apply it to the new cases. However, today almost all the law is running and enacted by the legislature as statutes. Mr. Just write down what I delivered to you. Just write down. No, just you have to write down. And we know, however, today almost all law is running and enacted by a legislature as statutes. But how can we actually interpret or construe that? This is the London and Northeastern Railway Company versus Birmingham 1946. This is the landmark decision, Smith versus Hughes. And not only that, the famous case law in our country like this, Dr. Muhyiddin Farooqi versus Bangladesh. 41, the Appellate Division, page number 4. What exactly that was? 65. This is the page number. And not only that, today's picture is that many institutes codify established common law, change it or abolish it altogether, depending on the topic of the law. There are instances in which some unwritten common law is still imposed, but these are rare. These are not significant in nature. In a common law system, such as the war in the United States, the court's reliance on precedent is referred to as stare decisis. To to stand by the way. This is the state decisis. There is a distinction between the two, state decisis and habitat dictum, which will be prevailed and which will be discussed in earlier UK case, Danugo versus Stevenson. Oh my God. Well, policy of using judicial decision made in the first in interpret written laws and appropriately apply those laws to the facts in the present case. The court interprets written laws, and this interpretation and application of precedent from prior interpretation constitute what is meant by common law today. Precedent is critical for interpreting legal cases, and only the sum of higher court can overturn the precedent. The court process is adversarial rather than investigative, which is side trying to frustrate the court to agree, which is prospective. This is totally adversarial system that the legal system in the world in attacking this the common law system. And this is the contradictory matter in terms of the civil law. So now the question matters before us, what is precedent actually? That should be prescribed from the side of law doctor to the barristers. Those who are going to be a barrister, you need to follow the instruction, and you have to follow the instruction of the law doctor. And to the session, as you're the students of Harvard, or the Cambridge, no matter, or the Oxford. So you need to follow the instruction from the side of the law doctor in the world. As you know that the law doctor is the best law academy in the world. So what is precedent? This is our turn to describe it. Common law codes are adversarial in nature. This is the adversarial. Win-win, or what exactly the win-win situation is not being practiced here. So win and loss, what exactly the thematic approach is being played here. There is when what attacks all, what exactly attitude in the coup in an adversarial system is what exactly is what determines the issues and question. It wants the court to resolve, conduct its own investigation, and the prefers and present its own evidence inside calls witnesses. So what is the main, what exactly the theme of that very legal system? The main theme is that's the win-loss game. In the world, this is the win-loss game. That is not totally the systematic in terms of the what exactly the good governance. This is not being practiced in such a way that the win-win situation between the parties. This is totally the vague idea, and this is adversarial in nature. There is the win-loss game in the world. This legal system is very much difficult in nature. So each side to bring out information, it thinks that the pertinent to prove its point. In a criminal case, the police and prosecutor work together closely to establish their viewpoint using the government resources. Defendants must rely on their attorney or using a court appointment. In a civil case, the procedure is similar. However, each side must rely on its resources to prove its point. If a jury is present, it decides all factual questions, when the judges determines the legal issues and moderates the proceeding. In some cases, the judge can act as a fact finder in the place of jury. So this is the very much difficult. This is the prosecution must just follow the instruction of the law doctor. So it is a primary. The general concept is that there is an opportunity and the burden of proof lies upon the prosecutor or the prosecution. But unfortunately, the shifting burden of proof, the shifting matter, how can it shift from prosecution to the accused? That should be focused here. And that's the intoxicated matter under section 67 to 95 of the Penal Code 1860. This is the matter which will be enlightened in what exactly this is the Penal Code. So those who are going to be barrister, they have the opportunity to study the comparative study of the laws. They are not actually they need not concentrate on point of the UK law only. They have the opportunity to study the law, which is comparative study of the law in the whole world, that the legal system will be prescribed process from the side of the law doctor to you. So not only that, now my turn in terms of the civil law system. What is civil law? This is totally the opposite side from the side of common law system. Most of Europe, the European countries and South America use a civil law system. But unfortunately, the origination from this is the origin of civil law in France. Exactly, France is the country, the state of Europe. This is the Europe. Okay. But unfortunately, only one lady is watching this video. This is shame for the whole nation. How can we challenge towards the whole world? This is impossible for the nation, as we are ignorant to understand the legal system in the whole world. Yes, this is totally vague idea. No one is watching this video, as we are lag behind. We're not adroit in law, and we are lag behind in the war. So this is totally vague idea in the war. Unfortunately, this is totally vague idea. This is the verdict of barrister. You are going to be a barrister, the famous barrister in a country. But unfortunately, this is shame for the whole nation. So the most of Europe, South America uses a civil law system in the war. So this is totally the inquisitorial system, as opposed to the concept which is derived from the common law country. In civil law system, court cases are investigation by the courts. Well, this is systematic way. How can we actually discuss in terms of that? What exactly the most of Europe and South America use a civil law system? A civil law system relies on comprehensive legal codes that contain all laws for the country. Case law, that is the judicial decision, is secondary to this code. And decisions are binding only on the parties to the case, not the president, for later cases on the same issues and to the cases. And when attorney will consent to your decision, and when advising clients, judges are really bound to follow the president. And what exactly the president, for example, this is the Marwari versus Medicine, and not only that, this is the state versus Dasho, and not only Donigo versus Staben, which will be highly what exactly they followed the landmark decision in terms of his decisis, and there is the option in terms of the habitat teacher. Oh my God, this is being practiced in common law country, but unfortunately president is not being practiced, especially in civil law system. But totally this is not true in nature. For this reason, codes of statute are usually more extensive and detailed than in common law systems. Oh my God. In civil law system, court cases are investigated by the court. Of course, the system is more inquisitorial. Okay, this is the systematic way. Inquisitorial, and not this is treated as to the adversarial. Of course, this is not adversarial system as opposed to that. This is the win-loss game in the war. This is the legal system. But totally this is systematic. These two systems, common law and civil law system, are the most widely used and legal system in the war. They differ in terms of the care to the judicial president and their views and purpose of this trial process. Oh my God. Now the religious perspective, how can we actually start discuss in terms of the religious system? This is religious in a religious law system. The law relies on religious texts as its primary basis, and the courts interpret the present facts and statutes in light of those religious texts. Many Middle East countries use religious law system for all or part of their laws. For example, in Saudi Arabia, the legal system is based on the Sharia law, derived from the Quran and the Islamic religious text, as well as from the Sunnah and the Hadith. What exactly Hadith? What exactly the Bisharabi sallallahu alayhi wasallam? So this is being practiced in the religious system of, this is the legal system in terms of religious legal system in Middle East countries. The legislature enacts the statutes, but all tested against Islamic tenets, and certain religious leader can overrule any government act, including courtization, religious grounds. The legal system includes general and summary Sharia codes, with some administrative tribunals for specific topics. Religious law system do not use into it, and this is the criminal trials do not present defensive evidence to some extent as in other legal systems. If judges or specialists in the religious Sharia tracks max their interpretation of the law and is not bound to by the president. And this is not Israel. Israel also used some religious laws and codes to determine cases. For example, religious codes in Israel includes Jewish, Arab Nikal Code, Islamic Sharia codes, Druze religious codes, and ecclesiastic codes of the trans-recognized Christian communities. In Israel, these codes are limited to some specific issues of family law. The secular code system decided all other matters. Oh my God. So this is the religious legal system in the world. And not only the customary system. What exactly the customary system? You have all know in this regard. This is the customary system. What exactly Chakma? This is the tribal culture. Exactly. The customary law is the system based on a long-standing tradition in a particular community. So the particular community exercise in terms of this is the systematic way. Wow. So this is the particular legal system in the world. This is the legal system in the whole world. Wow. This is the tribal concept in the world. And the customary law system is a system based on long-standing tradition in a particular community. The traditions have become so ingrained in society. This is significant that its codes recognize them as enforceable rules. However, it is rare for customary laws to be interpreted and enforced by the government. It is the select of the leaders of care usually implement the customary law. As a result, customary laws are typically unwritten and revealed only to group members. Today, customary law are found in closed, isolated communities. And this is the combined with the common and civil law system that can be followed here, that the legal system in the world. Oh my God, legal system in the world. In the war and the methods. Oh my God. Legal system in the war. That should be fresh up here, but no one is watching this video. This is very much shame for the whole nation, as we're ignorant, as we're not addressed at home in English, not to approach in this regard. Oh my God. So, on Andorra, a small country in what exists the Pyrenees, bordering Spain and France, relies part on customary law. In Andorra, source of customary law include canon law. You all know this is the canon law. What exactly the canon law? So the ecclesiastic law, what exactly the ecclesiastical law of the Catholic Church, what the Castilian law, French law, and Roman law. Andorra was invaded and under the control of other European powers at different times in its history. And the Andorran legal system now reflects elements of its invaders' laws. So those who are the invaders. So this is the highlighting approach today. And France and the Roman Catholic Bishop of what exactly the Catalonia, what exactly the Argels, the Andorra also as an elected parliament that can enact new laws. Oh my God. So this island chapter, so this is the hybrid, and the last but not least, the hybrid system. What exactly the mixed system, or the mixed legal system in the war that should be focused by us to you and towards the society. Exactly. How can we actually discuss in terms of the hybrid or the mixed legal system? But we are practicing the hybrid system in our country in terms of the politics or the economy or the legal system, or in every sphere of life. We are the hybrid leader in the world. System combines parts of more than one approach to create a system unique to country. Many countries have mixed legal system incorporating common, civil, religious, and customary law systems. Oh my God. For example, the US state of Louisiana. Have you heard the name of Louisiana? Where from this is built and how much dollar is needed to buy this Louisiana? Have you any idea? Of course, you have idea. So the US state of Louisiana has a hybrid system. Louisiana uses some common law, but it also utilizes civil law system for most of its state law, and faces that because of its origin in the French territory. Also, on a recognized tribal lands, customary laws of the tribe may be used rather than state of federal laws. Another example in the Philippine system. This is the Philippine. Oh my God! So how can we discuss that system very well? Oh my God! My friend is calling me, and messaging system from the side of Rumana. Rumana Akhtar, dear, how do you do? So the system in terms of US Israel common law, Sharia law, and indigenous customary law due to its history. Many African countries, for example, there is the countries including a federal, tribal, and ethical legal system to the adjudicate family law matters. For example, the civil law, here the civil law country, you know this is the Mali, Niger, oh my God, Chad. What exactly the Central African Republic? This is Democratic Republic of Congo. Those are practicing Angola. And not only that, those are the practicing, you know, Ethiopia is the civil law country. The practicing, this is the civil law. But unfortunately, this is the common law country. Here we find that's Nigeria. You have all know that's the Nigeria in Africa. Africa, prescribed that the Nigeria is the common law practicing country in the world. And that is not the Liberia, and not only that's the Togo, what exactly the but unfortunately, Benin is practiced in the civil law country. But Islamic law prescribed that this is the Somalia. Oh my God, have you heard the Somalia? Oh my God, Egypt. And not only that's the Egypt, and what exactly the Libya, and not only Morocco, Western Sahara, and what exactly the Mauritania. And so those are the countries who's practicing this is the Islamic law or the Sharia law. Oh my God. Now the practicing customary law, which country actually customary law? There's the Malawi. What exactly the Malawi? What exactly the Mozambique? What exactly the Mozambique and Malawi? These are the two countries they're practicing the customary law in the world. But how a mixed system in the world? Those are several mixed system. For example, how can that's the mixed system here? For example, that's the Louisiana. And this the Andorra. They are practicing the mixed system in the world. This is totally what extent of understandable, comprehensible nature. And how can we actually discuss the legal system in the world? Those who are going to be barrister in future life, you must follow the instruction of law doctor, as you know that the law doctor is the best law academy in the world. So today's number, bye bye.